Okay. All right. So I am very pleased to introduce you to Katie Martinka, and she is an employment law, uh, um, she's an employment law counsel, and she's based in Sedona, which happens to be one of my favorite places. So she knows all about the vortexes and all of the wonderful things that happen in Sedona. So she's bringing all that great energy to us. So, Katie, I'm going to turn it over to you.
Thank you. Good morning, everyone. I have been practicing law in California and Arizona for 30 years, and I represent executives as they onboard and exit their companies. I'm delighted to be here today to help you better understand the dynamics of executive terminations and to provide you with some strategies and tactics for dealing with your termination and severance negotiations. I'll take you through about approximately 35 minutes of content, and then we'll have some time for Q&A. During the presentation, you'll be muted. Please note that this presentation is being recorded, as Tina said, so that it can be made available to you and others afterwards. It is subject to the following terms. This presentation shall not be used for commercial purposes and is not intended to be legal advice. You should consult with an experienced employment law attorney who is licensed in the state that you live and work in regarding your specific situation. Now, let's get started. Our agenda for today is discussing the broader context of executive terminations, some staggering US layoff statistics, effects of termination on the individual, the documents that govern the framework for your employment relationship, the fact that severance is not required of employers in Arizona or California, some of the reasons why companies offer severance, how to get organized for your negotiations, the importance of hiring effective employment counsel, assessing and prioritizing your objectives for your particular severance package, the negotiation process, and moving forward. Just so you know, if you're just listening to this, I will not be reading all of the slides, so you'll want to get a copy of those later. Let's begin with executive terminations and their relationship to severance.
And Katie, we're not seeing your slides. Did you want to share your presentation?
Yes.
Okay.
Thank you for letting me know. I thought the slideshow was rolling along here.
I wasn't sure.
And can you see it, executive terminations now?
No.
We're not seeing your slides at all.
How about now?
Now
There
we
we
are,
go.
yes.
Excellent. Okay. There are many factors that influence a severance package. At a high level, who you are and how you got here are going to be key. Note that the average tenure of a C-suite executive is about 5 years, and the average age of a C-suite member is 56. An important point to bear in mind is that employers are more likely to negotiate individualized terms with senior and specialized employees. Beyond your position, who are you demographically? Are you in a protected class? What's your gender, race, religion, sexual orientation? Are or were you pregnant, or did you suffer from some other type of disability during your tenure at the company? Also, what were the circumstances leading up to your termination? Were the conditions in your company environment collegial or toxic? Were you climbing the corporate ladder or being passed over for promotions and perks? Are there any promises, practices, policies, or contractual obligations that your employer has not fulfilled? These are all important questions to ask in this context. Now let's move on to some frightening statistics. Nearly half of Americans have layoff anxiety. And it's not for no good reason, because during these challenging economic times, many companies, big and small, are facing the hard reality of layoffs. This is one of the biggest causes of executive terminations, yet roughly half of those who are terminated are unprepared for it. As an executive, you may have seen some advance warning of layoffs, but in many privately held companies, power tends to be more concentrated and there's less transparency about the company's current financial condition and plans. If you've been laid off in the past, ask yourself, were you prepared for it? And are you prepared for it now? Now I'd like to turn to the personal fallout that you as an individual may experience after a termination. Going through a separation of employment is akin to going through a divorce. The effects of being terminated are multifaceted, and it's important to remember that grieving is not a linear process. You may go through a roller coaster of emotions and start feeling less than without your daily support system at work. Also, when faced with emotional and financial distress because of the layoff or termination, you may not be able to think objectively concerning your rights and options. This in itself is a great reason to consult an employment attorney who can help you navigate this process. You need someone in your corner who can advocate for you and who can calmly assess your matter in a broader context. Now, I'd like to cover some common mistakes that I've seen executives make when they're in this compromised state of being. Serving as employment counsel to both companies and executives for more than 20 years, I participated in both sides of executive terminations, and I understand how the game is played. Time and again, I've witnessed executives making mistakes as a knee-jerk reaction to being terminated, and these mistakes can translate into them receiving less or even no severance. It's important to pause, reflect, and strategize before making a move that may jeopardize your package. When we experience emotional pain, there's a tendency to want to share it with others. That's really natural. Some of executives, though, unwittingly use their exit up interview as a vehicle to get back at those who have wronged them during their time at the company. This is a big mistake with potentially far-reaching consequences. I recommend either skipping the exit interview entirely or saying as little as possible during it. Otherwise, by some twist of fate, should you seek to be rehired by this company or an affiliate in the future, you may find that you've burned some bridges. Also, you want to be careful and cognizant when dealing with company information and resources. Companies may decide to dedicate IT resources to determine any actions that you may have taken to misappropriate their confidential information. I've also been involved in matters where the companies go fishing for inappropriate content on company resources. For example, porn on company-issued laptops or phones as a way to get out of paying you your severance. Finally, regarding making negative comments about the company, note that many agreements contain clawback provisions for breaches of confidentiality, IP theft, and disparagement by the executive. This means that you may have to pay back some or all of the severance that you receive if the company can demonstrate that you violated the terms of your agreement. Now, I've just provided a few tips on what not to do, and I'd like to add some color to those for you in hopes that if you take away nothing else from this presentation, that you'll remember one or more of them. First, on resisting the temptation to start calling your former coworkers, colleagues, the local newspaper, and anyone else who will listen to you regarding the severance offer you've just received, please exercise some restraint. Unless you're a top executive of a publicly traded company, the company has an interest in trying to protect even the existence of, not to mention the terms of, your agreement. I had a client who blabbed about her agreement, and after the company obtained a sworn declaration from the person she told, she had to pay a penalty of $10,000 per the terms of her severance agreement for that one indiscretion. Next, on downloading company confidential information to a flash drive, for example, I once represented a CFO of an insurance company. The client had executed a non-disclosure agreement when he became an employee and was terminated just 1 year later for no stated reason. We argued that the termination was retaliatory and a failure to accommodate my client's disability after a car accident left him with a broken leg and complications therefrom. After about a month or so of negotiating, we arrived at a nice settlement package for him. 3 months severance, continuation of medical benefits, which was very important to him, outplacement and reimbursement of all of his attorney's fees. Unfortunately, unbeknownst to anyone else, he had downloaded sensitive and confidential company information, including client information, and the company discovered it. They pulled the offer on the day we were poised to sign off on it, and my client walked away with nothing. Last, regarding making negative comments about your former employer, consider this. I represented the CEO of a company who had an employment agreement, but it was in a very contentious relationship with his board of directors. He felt micromanaged by them, and they had a heated split. He then immediately went online and started posting barbs about the company anonymously, he thought. The board was able to trace the social media postings back to him and refused to pay him his severance in spite of his written employment agreement for same, because of the disparagement, which there was a non-disparagement clause in the agreement, and he too walked away with nothing. Don't let any of these things happen to you. You're now forewarned. Let's shift gears and talk about the documents that govern the employee relationship. These are the ones and zeros of your employment relationship and form its framework. Currently, every state except Montana has at-will employment. This means that unless you have a written agreement guaranteeing your tenure for a specific length of time, you can be terminated for any or no reason as long as it's not unlawful. The agreements you signed at the beginning of and during your employment may impact the events surrounding the termination of your employment and beyond. Conversely, those agreements may not be legally enforceable at the time of or post-termination. These should be carefully reviewed by an attorney in the broader context of current law, your severance package, and your future career plans. For instance, let's say that you're a career financial advisor and you've just been terminated. I've represented several such advisors in the past whose employers have tried to shackle these professionals and prohibit them from soliciting clients of the firm when they go elsewhere, which is their life's blood. With limited exceptions, California courts have held that these non-compete and or non-solicitation of client agreements are void and unenforceable as a restraint on trade and in violation of public policy. There is a broad spectrum of possibilities here regarding what you may be offered for severance. You may have a written employment agreement, or on the other side of the coin, your employer may offer you nothing at all when you're terminated, putting the onus on you to make a case for severance. If you're in the C-suite, you may be lucky enough to have a written agreement which specifies what severance benefits you'll receive upon termination and under what conditions. That said, a written agreement is no guarantee that the company won't try to weasel out of paying you what your contract says you're entitled to. I've represented top-level executives who were terminated ostensibly for cause, i.e., some type of prohibited infraction, so that the company wouldn't need to pay out hundreds of thousands of dollars or more. Yet, no specific cause was provided at the time of termination. This could be triggered, again, by a heated debate, disagreement between the executives, the CEO, and a board member, or for a host of other reasons. The company may then go on a post-termination fishing expedition to see if it can dig up dirt on the fired executive. Alternatively, as an executive, you may not have a written agreement specifying what you're entitled to if there's a change in ownership or management of the company, and you'll need to look to other documents and factors, such as policies, prior company practice, and oral agreements as a basis for severance. So, why do companies offer severance? By and large, they offer you severance to keep them focused on and engaged in the jobs that you're doing while the company is going through a big change, sometimes very challenging circumstances, so that their key executives aren't out job hunting, and to provide a bridge to the employee to his or her next opportunity. On the dark side, let's turn to some of the self-serving reasons companies offer severance, as these may be key to your negotiating power. It's important to remember that no matter what the reason for your termination, your company may offer you a package to protect their positive image and deter legal action from you and others. You may know where all the bodies are buried. Especially in this age of rampant social media, companies and those at the top of the food chain among them do not want their dirty laundry aired. Negative publicity is anathema to almost every company. The company wants you to walk away quietly and go on about your business. So, the severance agreement is almost always going to contain a broad release of all claims by you against the company. It's important to note that there are some claims that cannot be released by law, and this is also an area that you should consult your attorney on. On the last point here, the company must give the employee something that he or she is not already entitled to obtain a release of all claims from him or her. Just paying you all of your earned compensation does not constitute legal consideration for the release. So, what should you do next after you've been terminated? We've talked about what you should avoid doing, as well as some background on why companies offer a severance. Let's assume you've been terminated, and now what? I recommend that you act as if every word of every communication you have from that moment on is being recorded. More on that in a minute. Remember, HR is not your friend. Also, the burden of proof is going to be on you, at least initially, for any claim that you raise against your employer. You should start by collecting the key documents governing your employment and other documents that may be relevant to any claims you may have. For example, pay stubs, performance reviews, bonus plans, etc. And also do some homework on the company. Search the web for what the company is currently posting. Look for any recent press releases, financial filings, and anything that may impact the company's health and reputation. It can also be helpful at this point to create a timeline of events from the time you learned about the position that brought you to this company to the time of your termination. A good attorney will ask you for one as well. A word of caution if you're planning on recording communications between you and HR and/or others at your company. States differ widely on whether you need the consent of at least one party to the communication or all parties. Arizona is a one-party consent state, and California is a two-party consent state, requiring the consent of all parties to the communication. Now let's turn to the agreement itself. Severance agreements are regularly the topic of litigated disputes in both federal and state courts. Be aware that if you've been provided a severance agreement, the clock is ticking. Of course, the company's goal is to get you to sign the agreement ASAP, and many of my clients have been reported being pressured by their employers to sign immediately, or the employer, through HR, engages in continual follow-ups with the departing employee. Don't fall for it. Depending upon your age and the state you're in, you'll have different amounts of time to review your severance agreement. You don't ever have to sign it on the spot. Always ask for more time to review the agreement than you think you're going to need. Remember, this is a big deal. You should give yourself as much time as possible to evaluate what's on offer, review the events leading up to the termination, prepare alternative strategies, and then execute on them. Think back to when you made a major purchase like a house. Did all aspects of the transaction go smoothly without any snags? Probably not. There were inevitably delays, scheduling conflicts, need to find more documentation. And while your attorney can seek to obtain additional extensions for you, it's a good idea to give yourself some breathing room at the outset. That said, get going and don't stick your head in the sand playing ostrich when you should be actively engaging in the process. Moreover, many individuals I represent have either not engaged any attorney in the past, or their experience of attorneys is limited to estate planning and perhaps divorce counsel. Give yourself some time to locate effective employment counsel, interview, and then engage them. I find that people often underestimate their value to the company, what the company is offering to others, and what the company can provide in a severance package. An experienced employment law attorney will assist you with evaluating the strengths and weaknesses of the severance offer you've been given. He or she will look for other payments that may be due to you and recommend important legal protections to help you start your new job search. Remember, this is a complex and specialized area of the law. Even a family or business law attorney can miss important points. You wouldn't go to a podiatrist for an ear infection, would you? Next, before negotiating your severance package, it's critical to carefully assess your objectives and make sure that you know what you're already entitled to receive. Your financial objective may, of course, understandably be at the top of your list. The single most question I'm asked is, can I get more money? And that's going to be dependent on a few different things. If you're in an industry that provides for deferred stock options or bonus, it's important to understand and analyze whether you'd still be entitled to those at the time of your termination. Your ability to get more of a severance payout is largely the result of asking for it by using a compelling approach and rationale. Do you have any valid legal claims against your employer? How many employees were affected in this termination? Was it just you, or was it a mass layoff? These are important considerations. When I say a valid legal claim against your employer, I'm talking about both during and at the time of your termination of employment, i.e., were you paid out all of your wages, salary, earned bonuses, commissions, vacation time, etc., and in a timely manner? Failure to pay earned wages when they're due, when you leave, subjects the company to penalties and potential liability for the employee's attorney's fees and other, if successful in making a claim. If this is a mass layoff situation, the company may have a very formal severance plan that is subject to federal laws. And this could impact your rights and your ability to negotiate disparate, individualized financial and other terms. That said, receiving a severance package as an executive generally grants you negotiation leverage, allowing you to pursue your preferred terms. Severance agreements cover more than just money and restrictions on you. There are key elements that may affect your brand, future job opportunities, and the time it takes you to land your next position. Many severance agreements are silent about the references that an employee will receive from the employer. In effect, this means that your employer's human resources department will only give out a minimum of information about you and your employment with the company. Generally, your dates of employment, your title or titles that you held, and your compensation. This lack of information can make it very hard for you to find a new job, especially at a high level, and if you've been out of the workforce or the job hunting scene for some time. You may be able to control the type of reference you receive by getting a letter attachment of reference, or even just a bullet pointed letter signed by a higher up at the company that allows you to show your accomplishments over the past X years. Before you sign a severance agreement, think about the type of reference you would like and who prospective employers would contact for that reference. With the rise of social media, almost all severance agreements that I review include a one-way non-disparagement provision in favor of the employer. Think about your current workplace situation. Are there any individuals who might wish to malign you in the future? If so, you may want to require that the company rein in their behavior. Also, regarding outplacement, as you may know from your experience with our host, PRG, a smartly written resume, a call from a respected recruiter, interview preparation skills can all be game changers in your career development, especially if you haven't had to search for a position in a while. Companies are generally willing to allocate money in a severance package for coaching, personal brand building, interviewing skills, and/or other transition services for their executives. Through years of experience, Employment Counsel will have picked up valuable insights and fundamental understandings of how severance package negotiations work. You should not try to negotiate on your own. Your Employment Counsel is not hampered by the emotional and psychological impact of your termination and can aggressively negotiate better terms on your behalf. In my experience on both sides of executive terminations, a company's first offer is usually not their best and final offer. Be patient with yourself. This is a process and no one wants to go through it. Lean on your support team, your spouse, domestic partner, attorney, and financial advisor. If the company refuses to agree to your severance asks, you can then make a written demand, sometimes accompanied by a draft complaint, to bring your employer back to the negotiating table. You can also file complaints regarding your legal claims with the EEOC or a state equivalent. This can also serve the purpose of bringing the employer back to the negotiating table rather than face a federal or state investigation. Lastly, you want to embrace change. Look forward to your next career opportunity. Reflect on the lessons you've learned, what you may do differently next time, and then set yourself up for success. Start networking. Maintain your network even at your next company. Do a better job of record keeping. In summary, we've talked about terminations, the reasons for them, the effects, the documents that govern them, what to do and not to do when you've been terminated, key documents to gather, severance agreements, preparation, the importance of hiring effective employment counsel, assessing and prioritizing your particular objectives, negotiating, and moving forward. Thank you very much for your time and attention today. Now I'd like to open the meeting up for questions. Please raise your hand and a PRG representative will unmute you.
So we do have a question in the chat already. So I'll read what that is. Bill, thank you. What is a reasonable amount to pay an employment attorney to review a severance agreement, and how long should it take the attorney?
Every agreement is different. And in my opinion and history, 2 hours of time is the minimum that I will engage with any client, because it takes time to review documents, whether they're a few pages. I've seen some that are 75 pages long. So there's no standard, and it's all over the map. And I often ask clients, how long is the agreement? Are there attachments? Did you sign any other agreements at the beginning of or during your employment? Because all of that will need to be taken into consideration. Most attorneys that do this type of work do not charge on any contingency basis. Your success is not determinative of their fee, nor really should it be. So you'll be paying by the hour most likely.
Thank you.
Thank you.
Okay.
Amy has a question. What is a quick and reasonable way to find a good employment attorney?
Ask your other trusted advisors. Everyone has a trusted network, and that's the first place that you should go. You should not go to the Yellow Pages. You can go to your county bar association. They have referral services in the state and county that you live in, but 90% of my clients come through referrals in one way or another.
Great. Mary asks, what is the status of non-competes nationally? Also, are they governed by the state where employed, the state where the company is incorporated, or the state in which the corporation has its headquarters?
Those are great questions.
Yeah.
And I am only licensed in Arizona and California, so I cannot speak to nationally. But what I can tell you is I've represented many executives who are employed by companies outside of California. My clients have worked and lived in California, and therefore California law is applicable to them. I hope that helps.
Great. And Tom asks, does this group have a trusted attorney? Tom, are you asking if PRG does?
Well, I would almost suppose that Katharina is that trusted attorney, but I didn't want to go so far as to say it overtly. But should anybody be in that situation, would Katharina be the right person to contact, I suppose, in this group context?
Well, I
I'd
think
certainly-
Katerina would appreciate being contacted, right?
I would hope so.
Absolutely. And I have a network of attorneys myself, and I refer out to other employment law counsel because there are conflicts of interest between the parties. People live in many different places. People work in different places now. So happy to provide referrals and be a trusted resource for others.
Can I ask one more question, just because I love attorneys so much? What's an employment lawyer cost per hour these days?
That's going to vary depending upon where you live and the experience that the attorney brings to the table. So there are a variety of factors that are going to influence that.
Thank you.
Okay. And Bill, with another question. If your company is headquartered outside of California, can they deny you CalCobra eligibility after your 18 months of COBRA coverage ends?
That's more of a benefits question. So that's something that I would have to defer to a benefits specialist on. that's a little esoteric, but if you'd like to write to me, I'd be happy to look into that for you after the meeting.
Okay. And Jennifer asks, if the company is in distress and executive does not have standard agreements in place, what steps can the executive take to establish protection?
Establishing protection after termination? I'm not sure. Okay, I see. While the company is distressed, the executive is continuing to work at the company, but is concerned about their ability to get severance after yeah, that's a tough one, because it depends, is the company publicly held? Is the company privately held? There are a lot of factors. If you don't have an agreement, you can't get blood out of a stone. So if the company is not doing well, then it's going to impact everyone across the board in some way, shape, or form. But again, as an executive, you may be one of the last people there before the lights go out, and therefore you have negotiating power.
And Paul has his hand raised. Sorry, I didn't see it. So go ahead and ask your question.
Thank you very much. So I was laid off. Well, one morning the HR person came in and said, "This is your last day," handed me a check, and I said, "Is there any kind of severance?" And he said, "No, there's no severance." And so I was, I left on the same day at the employer's request. I had just received 2 pay raises and accolades from members of the board and the executive team. And so I have engaged an attorney to try to pursue some kind of legal action. He's doing it on a contingent fee basis. So, and I don't know whether or not your comment earlier about doing it on an hourly basis relates to when you're actually negotiating a severance package. Again, I was offered none. And also, would it be sensible to file in parallel a claim with the Department of Fair Employment and Housing? Thank you.
First, let me just say that I am not a litigator. I was in another lifetime 20 plus years ago. So employment litigators do take cases on contingency. As a negotiator and someone who's trying to find a mutually informal way to resolve an employee's or former employee's issue, I work by the hour. Second, the California rules of professional conduct actually prohibit me as an attorney from communicating with a client that's represented by counsel. So since you are represented by counsel, I think it would be best to talk to your attorney about filing an agency claim, because it's my understanding that you're currently represented.
Okay. Mary asks, how common is it to negotiate severance within the offer agreement?
Depends on your level. Depends on, again, publicly traded, privately traded, your level. I've done it for several C-suite executives, but you may have seen in my presentation, offer letters are not binding agreements generally. So it's always better to get an agreement that lays out all of the obligations. And typically, if you're going to negotiate an employment agreement up front, there'll be a form of what the release looks like that you're going to be asked to sign at the end of your employment. And there are a lot of other considerations. So typical for the C-suite. Below that, not so much.
Okay. And Jack asks, so we're looking at the opposite side here. Do you advise executives on how to terminate employees lawfully?
Yes, I do. I serve as part-time general counsel, part-time in-house counsel, and interim general counsel to companies, and have been in a general counsel role since the year 2000. So I do both sides of it, and that's why I have an understanding of some of the nuances and the levers that can be pulled.
Very good. And going back to companies in distress, and I lost the question. There's so many questions coming. Here we go. Is severance a prioritized claim in events where the company is in distress?
Depends. If the company's in distress and they need to keep their executives and others engaged because they have a certain skill set, and they may be offering them retention bonuses. There are a variety of mechanisms that the company can employ. So it just depends how they want to spend their dollars and where they can spend them, depending upon what their mandates are.
Okay. Do you recommend using a templated executive agreement or hire an attorney at the time that it's appropriate?
I recommend hiring an attorney because I represented a CEO that was serving as a CEO for 4 different companies, and that had common ownership of certain principles. And they started with a template, which was flawed, and then they used it 3 more times. So that didn't help us when the fit hit the shan, and I was now trying to negotiate for him on 4 agreements, all of which were equally flawed. So not a good strategy.
Oh, very good. Jennifer asks, what question should we ask of employment counsel, yourself, and for company before retaining someone? You've mentioned slime subspecialties.
I'm sorry.
Jennifer, why don't you ask it?
I'm sorry, that was supposed to say subspecialties. You've mentioned several. You've mentioned several subspecialties. Thank you, Apple Spell Correct. Several subspecialties of employment law. So what are the types of questions that we should be asking if we're looking to retain someone, either for ourselves or for our company?
Certainly. Years of experience. Has the attorney worked with both publicly and privately held companies? I've also worked with nonprofits, executives in nonprofits in Arizona and California, and they don't really operate any differently when it comes to severance than for-profit companies. But you want to find out, have they represented someone in your position before? If so, how many times? Are there elements that you're particularly concerned about, and what do they know about that area? And do you need an executive benefits specialist for what your concerns are? So really depends on your situation, but the things that you're concerned about are the things that your attorney should be concerned about and have a lot of experience dealing with.
Okay, thank you.
Very good.
You're welcome.
And Frank asks, how does at will affect, or does it, on termination? I think I hear you saying previous behaviors from the firm impact any severance settlements.
Yes, previous behavior, other severance packages offered to others under certain situations, all of that does come into play, but pretty much everybody's in at-will employment. At the end of the day, even CEOs with employment agreements, there'll be an at-will clause in that agreement, and it will say, even though we agree to hire you for 3 years, if you do one of these 5 things, we're going to get rid of you. And whether it's for cause or something else, really no one is guaranteed a position for any length of time that I've come across in this day and age. I think it's a thing of the past, and we just have to get used to that. It's more of a gig economy, and it's a fluid and dynamic situation, especially with all the tech layoffs that have gone on last year and this year and more underway. So I think you should just assume that you're an at-will employee and then consider carefully what tools are in your tool bag and how you're going to deploy them.
Perfect. So anybody else have other questions? I think we've covered the ones in the chat. Feel free to unmute. Oh, here's one. Can companies prevent remaining employees, supervisors, or managers from making a reference? Good question.
That is a good question. So I think anyone can informally serve as a reference. Okay. Anyone, any champions that you've had at the company, but they're going to need to be sure to say that they're not speaking for the company. And many of the agreements that I come across will say that any request for reference will be routed through HR, et cetera. And it depends, but in general, anybody can be a reference. You just can't be wearing the badge of the company. These are not the company's opinions that are being expressed. That type of disclaimer is going to apply. But I represented an executive at a utility she had been there for 2 decades. And so getting a letter of reference was so key for her, and a negotiated point. We went back and forth for weeks because she had pages of accomplishments. She had climbed the corporate ladder during those decades. And there was no way that she could go and search for another position now unless she had something to show them. What, 20 years? I mean, yeah. So, and the company was strict about their reference policy. So it's going to depend, but informally, that's why it's important to continue networking as well, even when you have a job.
Very good point. Any other questions? This has all been so enlightening. You can just unmute and ask a question if you'd like.
I'll ask the one I just put in the chat if it's okay. So I think you said earlier on that there's no valid non-compete clause that is valid in California, I think you said.
Okay,
Is that
that's a little broad. What I said was in terms of solicitation of the firm's clients, unless it's to do with trade secrets. So yeah, there are some exceptions, but generally, as I said, if you're a financial advisor and you leave that firm, you need to be able to solicit individuals to provide your services to. That's your life's blood. And so the company saying you can't do that and continue these personal relationships is void as a restraint on public policy. But when you're dealing with trade secrets of a company and utilizing their trade secrets or customer lists or that type of thing, there's going to be a distinction between what you can and can't do. So again, it's important to have the exact agreement reviewed by an attorney who's going to look for those triggers and look to see what's valid, what's invalid, and what the courts have upheld.
Thank you.
And that's in California. In Arizona, it's a little bit different, and in other places. So again, you have to look to the jurisdiction that you're talking about. But that's a good point.
Thanks, Katie. Liz, you have your hand raised.
Hey, thank you. So, Katie, I had a situation as I was negotiating an offer with a software company in Washington State where I live, and they're headquartered here. And I'd always had a severance provision in every employment contract at a fairly executive level. So it surprised me when their offer came through, no language whatsoever. When I raised this and was looking for coverage in the employment agreement related to severance, they were very, I just couldn't pin them down. They said, we don't put this in the agreements. We decide it situationally when the time comes. And I said, it feels like there should be some minimum language at this level. And you know, so I'm volleying for, why don't we just go ahead and put in something that feels fair to both sides? And so they said, well, what would you expect that to be, right? And, you know, solving for the first number on their side, get it. But I said, well, I can't imagine it would ever be anything less than 6 months. And they like guffawed and said that in fact, their founder CEO did not have 6 months in his agreement. So I guess I'm just curious, like clearly it didn't help me to have volunteered a period of time to cover the severance for, but is this a new direction in hiring, like where they don't even include it and make it an after the fact thing? And then because you know, just an interesting strategy I had not encountered, and I was also new to software when I was negotiating that offer. Curious on your thoughts.
Some states do, it is common for employers to have it in their handbook that what their severance policies are, that type of thing. Yeah, I don't know about Washington, unfortunately, but it's interesting information what the CEO did or didn't get for him or herself, because
Yeah, I didn't expect to be privy to that.
I'm representing a CFO right now of a company, and they're being acquired, and all of the top executives got separate counsel, and the CEO did not negotiate well for herself. And now she's been talking to my client, the CFO, about what we're negotiating, which is more. And again, these are individualized. You know, you're not being treated as a class in many circumstances, again, unless you're at a publicly traded company, and everything's pretty transparent in that situation. So I find that interesting that this is a departure for you in the software world in Washington, but every company is different. And if the top sets the tone and they don't negotiate well for themselves, yeah, that might be a red flag for you, as well as what other things you may be able to expect or not in the future. So you got to think about it that way.
Yeah. Well, as it turned out, there was a mass layoff. I was a part of it. It was the run up to an acquisition where they were, you know, positioning the business to be of a certain size and profitability. And it was publicly traded on the Australian Stock Exchange, which included a number of additional requirements. But they did the very formal notice to everyone that disclosed the age of every one of the existing staff, as well as the departing team members. And everything else appeared to be above board. I did ultimately negotiate my severance on the way out and secured things I needed, but it just was surprising it was such a piecemeal process and likely open for litigation possibility. Yeah.
That's unfortunate, but I'm glad you're out of it.
I'm
That's
out.
what
I'm
counts.
out.
You're moving
Yep, working on the
forward.
next thing. That's right.
Yeah.
Thank
Right.
you.
Thank you. We have 2 questions in the chat and just a few minutes left, so let's see if we can get to both.
Okay.
One, can you invite your employment attorney to be in the meetings with the company HR representative regarding the severance agreement, or do you have to go it alone?
Regarding the severance agreement, now usually what happens is the company will terminate you with your supervisor, some other executive, and an HR person, and then give you the agreement to review. So you don't really ever have a situation where the lawyer is going to be sitting in the room with you and HR regarding the document, and you don't have to sign it on the spot. In fact, you don't. you have the right to have it reviewed by counsel, and those communications are privileged and confidential. Next
Okay.
question.
We have
Last
1
one.
minute, so we'll ask the last one and then we need to wrap. I was a VP and worked for the firm for 3.5 years. I was offered no severance. Subsequently, a more junior employee who'd been at the company for only 6 months was offered 1 week severance for each month of service. In your judgment, does this different treatment strengthen my case in pursuing a claim?
Possibly. There are many factors that influence it, but when I see executives getting different amounts of severance, I look to protected classes. Is there gender discrimination, age discrimination, etc.? Is that a pretty wide differential there? So I would definitely look into it.
Katie, I think the questions would go on forever. This has been so informative and something close to all of us. It's always an area of question, and you have just been fabulous in providing such great knowledge. I know that we will send out the recording of this later. Are your slides included, Katie? I didn't ask before.
I will, yes, they will be included, and I will provide them to you immediately hereafter. And I appreciate the opportunity to speak to everyone today. I hope you had something.
Okay, and I'm sure your contact information will be there also. Thank you, thank you.
Absolutely.
You
Thank
were
you.
fabulous. And to all of you that joined us, thank you for joining. Have a great weekend, and we look forward to seeing you, I think, in a couple of weeks. So
Thank you.
enjoy the
Peace out,
weekend.
everyone. Have a great weekend. Peace
Bye.
out.
Thank you.